All right, I want to just make sure that I'm being crystal clear with one thing. I've made it sound, I think, up until this point, that most anything is a constitutional issue. And almost everything can be a constitutional issue. But in the early days of our constitutional court, there was very much a distinction of constitutional issues. So in terms of jurisdiction of the Constitutional Court and other courts, before the 17th Amendment of the Constitution, there were certain matters that were considered not constitutional and certain matters that were considered constitutional. And in short, the Supreme Court of Appeal was the highest court for certain issues, and the Constitutional Court was the highest court for certain other issues. Now, this may have led to people trying to skew issues in a certain way to ensure that they had access to the Constitutional Court. It also led to black letter law, meaning that certain issues were never going to be able to go to the Constitutional Court, regardless of whether or not the court in and of itself had jurisdiction, because the matter was in the public interest. So then we had the 17th Amendment to the Constitution, which opened the doors for the Constitutional Court to be the apex court on all matters. Remember, though, that the Constitutional Court has absolute discretion to decide whether or not to hear a matter. That, unlike the High Court, where judges don't get that discretion. You bring an application or an action to the High Court, it must be adjudicated. The judges can't decide whether or not to hear it. But on appeal, the Supreme Court of Appeal and the Constitutional Court have discretion to decide whether or not a matter A has any prospects of success, and in the case of the Constitutional Court, B, whether or not the matter is of such public importance or raises a question of law that it must be adjudicated and finally decided upon at the Constitutional Court. So now in all matters, you can bring an application to the Constitutional Court. Whether or not they'll hear you is a very different question. So, in short, your jurisdiction for constitutional matters, jurisdiction for constitutional matters. If you are raising a question of whether or not law or conduct is constitutional or not, and your remedy is that it would be struck, you are not going to the magistrate's court. Magistrates' courts are creatures of statute. They have a closed list of orders that they can grant, and striking out legislation or conduct is not one of them. You can raise constitutional issues in the magistrate's court, but not if the relief is to develop the common law or to have any legislation or conduct struck. So in the High Court, which is where you'll begin most of your constitutional litigation, you would bring a matter to the High Court, raise constitutional issues at the onset, and I'm telling you that you must do that. And then, should you lose and you want to appeal, you'd go to the Supreme Court of Appeal, still raising those constitutional issues, and the Supreme Court of Appeal can decide whether or not your matter has prospects of success or whether or not it's of public importance and the matter must be adjudicated. If they refuse, you would then still have the opportunity to go straight to the Constitutional Court. If the Supreme Court of Appeal grants your appeal, you can be heard there, and then you get a third bite at the cherry for appeal straight to the Constitutional Court. The Constitutional Court does not like being the court of first instance. The Constitutional Court prefers to be an appellant court where subsidiary issues have been finally decided, and the Constitutional Court only has one crystallized issue to adjudicate on. Whether or not that's a question of constitutional damages and no factual issues, or whether or not it is whether law or conduct must be struck. The Constitutional Court generally prefers to answer one distinct, difficult question as opposed to going through the weeds of the many other questions that could have been sorted out in appeal. So, the big takeaway from this section is that there was a 17th Amendment to the Constitution. It's been amended 17 times. You can look at all of the changes if you would like. But the 17th Amendment changed the jurisdiction of the Constitutional Court. And now, all matters, so long as they raise public importance, constitutional issues, can be taken directly to the can be taken eventually, not directly, eventually to the Constitutional Court for final adjudication. Matters, however, that would never be questions for the Constitutional Court to answer are questions about setting aside an arbitration award, questions about sentencing and less sentencing related to whether or not a trial was unfair or not. Questions of lower courts' mistakes in finding of fact. That is generally not, if you're only challenging factual findings, then that wouldn't be a constitutional issue. If you're bringing an appeal that challenges the incorrect application of law by a lower court, that's generally not a constitutional issue. That's something for the SCA to decide upon, but not ultimately to take to the Constitutional Court. So there are a lot of cases going on that I think will ultimately go to the Constitutional Court. The murder conviction of Jason Roeder in the Western Cape, for example, where he's alleging that his trial in the Court of Quo was unfair. The Supreme Court of Appeal has found that the judge had made erroneous findings. But to the extent that Mr. Roeder could take his appeal to the Constitutional Court, it would have to be on the basis that his rights to a fair trial were infringed. I think there's a lot of drama playing out in our courts right now, and it's quite an exciting time to be a young lawyer because there's so much media attention on it, and you can follow the streams of constitutional issues and start making your own predictions. Another thing that's extremely exciting at the minute is that since COVID began, the Constitutional Court hearings are available to watch on YouTube. So you can watch some of our best counsel bringing some of our best arguments to the Constitutional Court and what the judges ask and how they interact. Judgments are also being handed down via YouTube. So what I've found quite fun, and this is something that you can do in your lunch break if you're as much of a nerd as me, is you can watch Constitutional Court argument and then click to the next video and watch the judgment being handed down. So you can see the correlation between what the justices were asking and what they ultimately found. I know I'm a complete nerd, but this is really, really interesting stuff, and it's quite a fun time to be a young lawyer because you can learn so much from actual practical exposure to the Constitutional Court. Thank you. I'm going to go on to the next section now. On to the next